Satyapal Jain, Additional Solicitor General, now joins me live. Appreciate you taking the time out, sir. You just heard our guest there. He made a passionate plea against this particular bill, both inside the parliament and now outside on my show. The question that I ask you, Mr. Jain, with what is being debated vociferously, is the principle what has been natural justice. An individual is considered innocent until proven guilty. Yet, at least what the new bill seems to suggest prima facie is the removal of a sitting chief minister without being convicted or proven guilty. Somewhere, this is a direct breach of that very principle, sir, of natural justice.
See, in the Indian politics for a very long time, there has been a serious debate as to how the criminals and people with criminal background should be avoided from coming to parliament, Vidhan Sabha, and they should be kept away from the centers of power. Earlier, under the RPA Act, if you are convicted for a offence for more than 2 years, you would lose your membership, but a privilege was given to the MPs, MLAs, that this clause will not be applicable to them so long as their appeal or revision is pending. Supreme Court struck down that. Supreme Court said all are equal. This should be applicable to MPs and MLAs also. Secondly, later on, the Supreme Court also said that when you file your nomination paper, you must give all the criminal antecedents. Where were you involved? FIR, bail granted, not granted, convicted, not convicted. So this moment of keeping away the criminals from Indian political life, elected officers, is continuing for a very long time. This is a step forward in that direction, that those people, you may be a minister, prime minister, chief minister, if you are detained for more than 30 days in an offence where the punishment is more than 5 years, which are ordinarily the cases of moral turpitude, very heinous criminal crimes, the person himself should have resigned. But since the people are not resigning, I feel it is the right time that this law should be enacted. They should be disqualified from holding that office. But the bill also provides that in case ultimately you are acquitted, or you can become the same position again also when you are clear of the charges or clear of the allegations against you.
Moral turpitude and probity in political life, sir, many would suggest in this day and age has become an oxymoron. But I'll also come to a larger question which is being debated in this day and age of politics, that we are living in a time where constantly the refrain by the opposition is the weaponization of investigative agencies. Doesn't somewhere down the line attempt or risk turning agencies into, like the CBI, like the enforcement directors, into political actors?
No, not at all. Because first of all, let's understand one thing. Maybe CBI, maybe ED, maybe SFIO, they prosecute people against whom there are serious allegations. And as per law, any agency arresting any person, maybe a MP, MLA, a common man, a PN, or a chowkidar, has to be produced before the trial court or the appellate trial court or the session judge, CGM, whatever it is, within 24 hours. So first of all, after the arrest, it is the court which examines whether there are sufficient grounds for sending him to police custody or judiciary custody. After that, there are now under the PMLA, under various other acts, Supreme Court has gone even to the extent that when you arrest a person, give him the reasons in writing. Why are you arresting him? Then you have the best available lawyers available to you for getting bail, etc., etc. If you are not able to get bail, it means the court finds that there are serious allegations against you. Let's not forget, after the arrest, I'm repeating it, after the arrest by any agency, it is the court which decides whether to send you to jail or bail or remand or whatever it is. So therefore, the moment you are arrested, you are under the supervision of the judicial officer. You cannot blame the executive or the investigating agencies for keeping you in jail. That is the judicial discretion exercised by a judicial officer. So you can't say that it's something vindictive or it's just to put the people of the opposition parties in jail. Well, if you have committed crime, if there are serious allegations against you, only then judiciary will send you to jail. And if the judiciary has sent you to jail, you have no moral right to remain in power, because there are serious allegations against you and you should not remain in that position. Only minister, PM and all that Your membership doesn't go. You continue to be a member. It doesn't take away your membership, only the power. And let's not forget, in 1998, when Mr. Lal Krishna Advani's name was there, mentioned in Hawala, immediately the moment he came to know of it, he resigned from Lok Sabha and said, unless I am cleared by the Hawala court, I will not contest any election. Mr. Madanlal Khurana was the Chief Minister of Delhi. He resigned the moment his name was mentioned in Hawala. Mr. Yashwant Sinha, now he is in opposition. He was leader of the opposition, BJP in Bihar Vidhan Sabha. The moment his name was mentioned, he resigned from the opposition leadership of the leader of the opposition. Such are the moral standards which people have to set in public life. And I think those who are facing such criminal charges should immediately be removed from the office of the president, of the minister. And Act says so. Amendment says that either you resign within 30 days. If you do not resign, then 31st day you have to go home.
But Mr. Jain, the fact is you talk about the judiciary sending one to jail and it must be big enough. But there are certain archaic draconian laws like the PMLA which tie the hands of the judiciary. Laws that are being contended and contested in court as we speak. Where if you are arrested by the ED, the onus is on you to prove your innocence, number one. Where you can be kept in custody for 30 days straight without getting bail. Today we are talking about the PMLA which, which I just told you, sir, that you can actually be kept in jail for 30 days before you're even considered for bail. By that time, the chief minister or the minister will need to step down.
No. Please don't misunderstand the law. PMLA says in case you arrest a person under the PMLA, you have to convey him the reasons of his arrest, grounds immediately within 24 hours. And they are produced before the court when the court decides whether to remand you to judicial custody or to give the remand to ED or to release on bail. All powers are with the judiciary. Let's be very clear. After arrest, maybe by the ED, maybe by the SFIO, maybe CBI or police, the next step is by the judiciary. It is they who decide whether to send you to jail or not. So therefore, don't think, let's not remain under the impression that the government will arrest and put you behind the bars. They can do it only within 24 hours after arrest. They have to get the remand from the judicial officer.
But sir, I'm yet to...
It is a special court. The officer is of the ADJ district judge level, additional district judge level, or chief judicial magistrate. So I am very clear. This is a good step taken in the direction of cleaning the political life, Vidhan Sabha, Parliament, from the people having criminal antecedents.
Mr. Jain, correct me if I'm wrong, because I don't know a single case in recent memory where somebody who was charged with PMLA was given bail by the judiciary in less than 30 days. The law is so archaic and draconian, facets of which are being contested in court on the very fact that, like I said, I don't remember anyone who's been given bail in less than 30 days. You gave me some examples of LK Advani ji. That kind of moral turpitude doesn't quite hold in this day and age. At least we haven't seen it. Let me give you examples of certain chief ministers and leaders who've suffered at the hands of being in jail and maybe having to fight an election. Ms. Jayalalitha, Shibu Soren, A. Raja, Jagannath Mishra, all eventually acquitted by the top court. How fair do you think, sir, it is to remove a sitting chief minister who's been in jail and later is acquitted? And some of them have fought elections while they were in jail. Their parties definitely have.
Out of hundreds of the former chief ministers, center minister, you are pointing out only 4 or 5 names against whom there were serious allegations. And let's not forget about the basic principle of criminal law. If there is a doubt, you are booked. If there is a doubt that you have committed an offence, you are booked. And if there is a doubt, ultimately you are acquitted. Sometimes you are acquitted by giving the benefit of doubt. In public life, these are the leaders who are leading the public, who are setting example for the nation, who have to lead the nation, who have to lead the public. If they are facing such criminal charges, I personally feel they have no moral right to remain in power. Is this bill aims at making these people alert that look here, it's a warning to them also. All people who are in power, that if you do such type of things, it is at the risk of losing your membership, your ministership, your chief ministership. And let's not forget, hundreds and the hundreds are there against whom there are no allegations. Bad example will never make any law bad.
But Mr. Jain, there is a huge distinction on facing criminal charges and actually being convicted of those criminal charges. So recent history, sir, clearly demonstrates how opposition leaders have been arrested, held in custody for very long periods of time, only to be discharged later, especially in states where the chief minister is getting into an election to take in the leader of that party and the chief minister, arresting him, and then later on, if he gets bail, to put him back in the chair doesn't quite hold. You might call it want of evidence, but on the contrary, some of them have been acquitted completely.
Madam, this is applicable not to the MLAs, MPs. This is applicable amendment to the ministers, the chief minister, including the prime minister. Including the prime minister, this law says it applies to him also. And if there are very serious allegations, you don't remain in office as a minister, where you are supposed to lead the department. You take oath in the name of defending the Constitution of India, believing in the rule of law, that you will defend the law, the rule of the Constitution. When you are yourself an accused of a serious offense, then what right have you to remain in power? You should yourself withdraw from there. You should yourself resign from there, so that you set a good example. Now, so far as the amendment is concerned, if it is enacted, it will be now for the courts all to see whether this man should be sent to judicial custody or not, whether he should be sent to jail or not. You don't send, the government doesn't send a person to jail. The government or CBI or ED doesn't send any person to jail or custody. It is the court which does it. And if you don't have faith in the court, if you don't have faith in the judiciary, then I'm sorry, I can't comment on that.
No, sir, it has nothing to do with me. I'm giving you the call of what the opposition is saying. For example, the claim which has been made by Arvind Kejriwal that this is exactly what the BJP wanted. You tried to do exactly that, which is the BJP here, to make him and push him to resign. You couldn't do that, where he insisted on running his office from jail. Now, again, I'll come back to the PMLA here. Not just the likes of Arvind Kejriwal, the likes of Hemant Soren, individuals taken into custody, denied bail for over 30 days, multiple accounts coming out in the case of Hemant Soren, been acquitted, but being forced to fight an election with the taint of being guilty, which you are not ultimately, at least in the case of Hemant Soren.
Oh, no, not at all. Because once again, I am repeating, I am not aware of any clause that you will not be given bail for 30 days under the PMLA. I am not aware of it, any clause which you are mentioning. But
sir, I've given you the example of Mr. Hemant Soren. There's an example of Manish Sisodia. There's an example of Arvind Kejriwal. It happened with Shibu Soren as well. Multiple examples, sir.
It doesn't mean that simply because you are an MP or MLA, no action should be taken against you whenever, whether you are convicted, not convicted, charge sheeted, not charge sheeted, you are above law. Nobody is above law. An IAS officer who remains in custody for 24 hours or state public servant, is he not suspended immediately thereafter?
Fair point.
Why? He can also say the same thing, and every criminal will say, so long as I am not convicted, I am not guilty. It's not the question of convict or innocent and all that. It is the question of public morality. If you are facing such serious chances that the court also wants you to retain in jail, you have no right to remain in
public morality is something which really is non-existent. It's an oxymoron in political life, at least as of now. But you make a very fine point where you talk about, because the same yardstick is applied to civil servants, why are our politicians any which way special? I'm going to come back to now whether or not this bill will be passed or not, sir. The larger question now will be the passage of this bill, which requires 2/3 majority for the bill to be passed. Correct me if I'm wrong.
I think it's a constitutional amendment. I think it will require, but when it goes to JPC, I have been in parliament twice. JPC can examine all the bills which are sent to it rising above party politics. They will examine each and every clause, suggest the amendments also, then the report will come to parliament. I think it will require 2/3, but I can't say because I have not checked up just now the constitution. It might require, due procedure will be followed by the present government while enacting the bill. Discussion, JPC discussion, report in parliament, voting, everything will be done as per the requirement of the constitutional law. No law will be bypassed.
Well, due procedure would also mean, sir, by the virtue of ordinance, there was a departure that was seen in the abrogation of Article 370 in 2019. That time, the excuse was taken that it was a special temporary provision in the Constitution. Therefore, simple majority clause was used, enabling for implementation of the constitutional amendment. However, in this case, do you see any other legal loophole, sir, that could be exploited by
If
the
it is
government?
two-third majority, it is two-third majority of the present and voting, but simple majority of the total house. Two-third of the present and voting, and simple majority of the entire house. And I'm reminding those people who are opposing
Okay.
it, they are saying two-third and all that. They should not forget in 75, when they took away the right of hundreds of MPs, thousands of MLAs, lakhs of people, keeping them in jail without bail, without trial.
But sir, that's a political argument that you're making, aren't you? I'm talking about the legality of it.
As per the constitutional requirement, bill will be passed,
Okay.
and when it will be passed, it will be before the whole world. Parliament proceedings are live telecast.
Okay.
It can't be done in a secret manner.
All right, sir. Fair point. Appreciate you joining us, taking the time out. Thank you, Mr. Jain, for joining us on that.